bargaining is done on phone with a represented party without his lawyer. Plea bargaining involves telling an accused person you are prosecuting to forge a medical excuse duty. Plea bargaining includes telling a witness who by law is supposed to testify to matters he perceives, matters he knows to be true, persuading him to testify to matters that you think, you, an adversary, think to be the truth. Is that plea bargaining? You see, there's been a lot of talk about, let's talk in line with our training as lawyers. But what is actually being done on this platform is that the law and the training we've been given as lawyers is being turned upside down. This is the apogee of intellectual dishonesty.
I haven't
said the things on the table, what has that got to do with plea bargaining? We don't know what the plea bargaining law actually talks about. I've not mentioned anybody. I've not mentioned you, my brother. I've not mentioned you. Let the viewers judge. And you will realize that I've not interjected or echoed once.
Hold on for a minute. Hold on for a minute.
You're going to distort my thought.
Sammy, hold on.
Write what you want.
Keep your thought.
When you were talking,
I will not.
You even made personal
I will not sit here
against my person.
I didn't say anything.
And I wrote them down. I didn't
say anything against your person.
So you're going to show me the same respect.
Please. I've shown you.
And you're going to allow me to make my point. So take your pen and your paper. I've shown you. Write the comments I'm making which you disagree with. But I will make my point.
I've showed you.
If something allows you to interject,
I have showed you.
Then I must also be allowed to interject when you speak.
I have showed you.
So then allow me to make my point. Allow me to make my point.
Hold on for a minute. Hold on for a minute.
This show has rules.
I have shown you so much respect.
Please, let me make my point.
I don't intend. Wait, just a minute. Just a minute.
I don't intend that.
If you allow this, then you're going to allow me to.
I don't intend that you came here with an attitude to disrespect me. Because I have never disrespected you here. I have never.
What have I said here?
Please. You said I made comments against your person. I never. I have never made any comment against your person.
All right.
Please.
Okay.
All right.
Thank you.
You see, if Sammy Gyamfi is making a point, there are 3 discussants. Myself, him, and Kuku Pencil. I have never, throughout the transcript of this proceeding, said anything about plea bargain. So if he is talking in the context of plea bargain, he should situate it to Kuku Pencil. He should not use general words to describe all of us.
That's a fair point.
Please.
Okay.
Sammy,
Two things. Let me just respond. Number one, he says he has not spoken about me. He has. When he suggested that I have used interpret language.
Can we progress without this?
Allow me to talk, because you see, there are 2 people who are ad idem on this subject. They've had ample time to speak. Allow me to also make my point respectfully.
So progress on the substantive.
On the substantive point is that when he suggested that I was using interpret language, it was unfair because I have not. And as a lawyer, per his training, he knows that if I build my case and on the basis of that say that that case shows a lack of integrity on the part of the Attorney General, that is not interpret language.
His objection
now, let's go on.
The question of intellectual dishonesty on this platform.
Lawyers don't even say intellectual dishonesty in court.
On the question of plea bargaining, which he has not spoken to. So it's fair.
Oh, I will tell you.
Now go on.
Okay.
No, Sammy, go on.
Yes, I am going on. I'm going on.
Sorry, let's allow him.
The intellectual dishonesty in respect to him is about his use of the phrase that conversation we are talking about, the tape, was a without prejudice conversation. A telephone call conversation is not without prejudice. This is trite. And so, as a senior lawyer at the bar, you cannot suggest on a public platform like this, arguably the biggest platform in this country, that a telephone call conversation
let's not stay
between
there.
the Attorney General and a representative.
So go to your substantive point, then it will get to him. Yes.
No, number one.
Number one.
They say that the tape we are talking about, Mr. Davis says that it is doctored. As a lawyer, he knows the law governing the issue of doctored tapes. The case of Kennedy Japan versus Adduce is clear. If you want me to read, I'll read that to you. Even in the submission or the ruling of this trial court on the application for submission for no case answer, the judge lays that law very clearly. That when a person asserts the affirmative and another person asserts the negative, the burden of proof is on the person asserting the negative, the positive, to adduce evidence to support his claim. So if we have put out our tape and we are saying it is not doctored, and you say that it is doctored, the onus is on you to adduce evidence to show the doctrine. So far, you have not adduced a scintilla of evidence to show any doctrine. Again, you don't even have the locus in law to even say the tape is doctored, because what you're saying is total hearsay. You were not on that phone call. The person who was on that phone call is Mr. Dame, who is very vibrant in the media. Neither Mr. Dame or his spokesperson, my good friend Wilberforce, has been able, since we published this tape, he has been able on any media platform to say that the tape was doctored. Neither Mr. Dame or his official spokesperson has been able. The Office of the Attorney General has also not been able to even say that the tape was doctored. So that wishy-washy response is very weak. We can't work with it. Again, he says that the tape is pieced together. So he should tell us which parts of the tape we have heard is pieced together. You don't deny that there was a call. You don't deny that the voice on the call was Mr. Dame. You say that parts have been pieced together. Which part has been pieced together? Show us.
There was a part that was repeated.
Yes.
And I think they referenced that in their press conference to show the piecing together.
There is no part of the tape we put out which is repeated. Not even one part. Not even one part. I heard him at his press conference saying that the tape is doctored because we said we will start our press conference at 2 p.m. and we started around 3 p.m. so we were doctoring the tape. This is law. These are the people who say they are trained lawyers and they always speak in accordance with their training.
No, you cannot say that.
Okay, I take that.
You cannot say that.
I take that back.
You cannot say that.
Now, number two. Let me go on. Now, number two.
He's withdrawn it. He's withdrawn it.
Now, number two.
I don't like the way he stretched.
He's withdrawn it.
Because I have more vitriol than he has.
He's withdrawn it.
No, I have more.
Don't go there.
It's an opinion. And I respected your vengeance.
It's not an opinion. It's wrong. It's wrong.
You cannot
now,
say
Mr. Davis, you see,
he has withdrawn it. Sammy,
let's go.
Sammy, please.
Now, he also goes on to say
he has withdrawn that.
He goes on to say that on the tape, Mr. Dame is not heard coaching or persuading the third accused in any way. And Samson, you yourself, you said it on the tape. He is urging a position about the effect of letters of credit and what happened in the transaction, in dispute. And he tells the accused person that if you testify the way I want you to testify, if you testify according to my theory, my position, it presents no difficulty for you. It makes the matter simple. He says that repeatedly on the tape. Repeatedly on the tape. In fact, Asase Radio, which is owned by Gabi Ochredako, they put out a story. And in the story, they attribute quotes to the Attorney General. And if you look at those quotations, they say that at a meeting at the residence of a Supreme Court judge, the Attorney General, they quote him as telling the accused person that I will give you an exhibit, cabinet approval. I will ask you A, B, C, D. Answer yes to this one. Answer no. These are quotations put out by Asase Radio that Mr. Dame, very vibrant in the media, has not been able to dispute. So in the face of this overwhelming evidence, if you tell us, discerning Ghanaians, that he was not coaching him, he was not conferring with him or persuading him, what are you talking about?
Sammy, you know that as lawyers, we are not experts in everything.
Yes, we are not.
And particularly as we are in general practice, people come with their issue.
Yes.
We take the facts and put the law around it. You hear them discussing the LC.
Yes.
And you can clearly see that the guy is more knowledgeable about the LC than the AG. There's nothing wrong with that.
There's something very wrong with that.
What is it?
Before you go to court and build your prosecution, your case on an LC, you must first of all seek experts' knowledge on what an LC is. It is not when you have already opened your case and closed the case, and an accused person is going to court to testify, that you go to the accused person for education on what an LC is. No lawyer worth his salt does that. When you have already opened your case and closed your case, and now the accused person is going to court, what are you afraid of? That you can't wait for him to come to court and give his testimony. And if you disagree, undermine that testimony in the box, which is what any lawyer, any trained lawyer would do. Now, my brother, again, please. Again, he says that where is the criminal conduct? In the tape you played, even on this show, Mr. Dame is heard telling the third accused to even though he knew he was very fit to go and procure a medical excuse duty.
If that were proving, that is misconduct, not crime.
No, that is crime. That is crime because if you check section 213 and 214, fabrication of evidence, and 214, if I can I read 214?
But that will not be evidence.
That is evidence. Medical excuse duty, bringing a medical excuse duty to the court to say that you are sick when you are fit is what?
It's okay. It's evidence for what?
It is evidence to get the court to adjourn, to allow the Attorney General, the prosecutor, to travel. The Attorney General cannot tell the court that give me, an adjournment. He doesn't even trust his deputy and the DPP to take over the case when in his absence. He wants an accused person who is a witness.
But that doesn't contribute to the case. It doesn't contribute to the case. How the case, the judgment will be rendered.
Whether it contributes to the case or not is irrelevant. 213 says, anyone who fabricates evidence to deceive a court is guilty of perjury. And 214 defines what is that deception. It says that if you bring any circumstance to exist that deceives a court, you are guilty of perjury. So by telling him to go for a fake medical excuse duty, he was telling the witness to bring a circumstance to exist in court that would deceive a court. Then finally, my brother, Mr. Pencil keeps on saying that this evidence, even if true, borders on ethical conduct of the AG, it cannot impact. I don't understand this. We are all trained lawyers, again. Don't we all know, Samson, that every accused person has a right to a fair trial? And if the accused person can show evidence that a certain trial is unfair, malicious, that can lead to the termination of the case through an order for mistrial. This, if you look at even the affidavit that has now, the application and affidavit in support of Mr. Jakpa, asking for the termination of the proceedings.
Okay.
He is telling you that the Attorney General, he has evidence of the Attorney General telling him that he is innocent. He is not a target. He has no case to answer. But that due to pressure from the then finance minister and the President of the Republic,
as you can see,
the court will determine that.
As you can see, I was pointing out to Senior Pencil that if there is a possibility that this can impact on the matter in the sense that these applications, if they carried the two applications asking that the matter be, completely terminated, would have meant that it has impacted on the matter. But there's difference in opinion. So let me come to. That was your last point.
Oh no, let me just. Conclude.
You said last. Conclude.
I just wanted to reinforce a point that you made. That once evidence is relevant, as lawyers we know, that it matters not how it was procured.
R versus Leighton, even if it is stolen.
Exactly. Thank you. And when it has to do with evidence that borders on a crime against the state.
The question is evidence for what?
Evidence that shows
that the procurement of the ambulances were correct. That they were not vans fitted with kitchen.
Evidence that shows, evidence that shows that the case of the prosecution is based on nothing. They know that they don't have a case, and yet they have contrived the case.
All right.
They are contriving evidence, and they are willing to even commit crimes.
Let's come to Frank Davis.
In relation to
let's come to Frank Davis.
The pertinent issues that I think all of us should be.
Thank you. And